nothing more than political persecution and judicial harassment of a hero of Uganda. I want to also go specifically point number 2 to section 7 of the Human Rights Enforcement Act, which reinforces section 76 of the MCA that my senior brother alluded to. I will emphasize there are just a few subsections. Section 7, subsection 1 is succinct, where in any proceedings in a subordinate court, any question arises as the violation of a fundamental right of freedom, the magistrate shall refer the question for determination by the High Court. That is subsection 1. Subsection 2, where a human rights matter arises in any proceeding before a magistrate's court, the court shall immediately stay proceedings in the matter and first determine the human rights issue raised. And especially then subsection 3 relating to the liberty of the accused. A magistrate presiding over proceedings referred to above may stay the proceedings until the reference is determined and may, in the case of a criminal trial, grant bail the accused person. Of course, 4 says that the court shall dispose of the matter in accordance with what the court says, and the High Court is also given a timeline within which to operate according to subsection 5. So everything points to that today it's only the bail of the accused persons that this court can handle, and that the court's hands are tied. 1, to refer to the matter to the High Court for fair hearing, and as they refer it, to grant bail in the terms and following section 76 of the Magistrates Court Act. I will not respond to the whereabouts of the prosecution. Thank you.
Your Worship.
As a moment. Let him access the mic.
Your Worship.
It's okay.
And a little more emphatic. First, I associate with the submissions of Lord Mayor Elias Lukwago and the submissions of kizza. The state informed court that it was an agreed position on the 21st. The Worship, on the 21st of May this month and this year, the sitting magistrate informed court that he only had 2 dates of which he was guided to adjourn his case. That was on the 2nd and the 5th of June. The defense prayed for today. It was the decision of the sitting magistrate that the matter be adjourned to the 29th of May. The state has informed that there is a letter on record. I want to be clear on this, that I do not and we do not have a copy of that letter. But it is a command still about legal representation and adequate facilities to represent. I don't have the letter. This speaks loud that I do not have adequate facilities for fair representation of A3. It is just fair and in the interest of justice that the matter be adjourned to any other date. If you incline not to adjourn, actually when they informed me that Ola was coming to court, I thought I was coming to take Olabo. If it is the case, I will be happy to take Olabo. Short of that, the